The new book is really exciting for a couple of reasons. I'm thrilled about it. First, it's a chance to commemorate 10 years of the German Law Journal, which itself is a tremendous success, but because it's an online journal, it exists literally only virtually. And to have collected sampling of the fine work that the German Law Journal has published over the last decade in an edited volume, to have it in print, to be able to hold a piece of the German Law Journal is itself a pretty remarkable achievement. It's also a chance to recognize the more than 24 Washington and Lee University law students who have worked as student editors on the German Law Journal project over these many years. Maybe the most exciting thing is that it tries to resolve some of the big questions that surround this elusive field of law, often referred to as transnational law. The book takes a selection of German Law Journal contributions and makes an argument. And it makes an argument for both a definition of transnational law, and it argues for a methodology for how one does transnational law. So it's both backwards looking and reflecting on the success of the German Law Journal, but it's also seeks to be a theoretical and methodological contribution. And there are many scholars who argue that there is now a canon of transnational law that one should study and must be able to command in order to regard him or herself as a transnational lawyer. And we dispute that. We see transnational law, and we demonstrate that through the pieces we've collected here. We see transnational law rather as an event and not a static body of law. Transnational law exists as the meeting place between different approaches to law, the nexus, you might say, of different legal cultures. The book contains a broad variety of material, and that's maybe one of the really exciting parts of the German Law Journal project, is that it's so flexible and so diverse, both in its methodology, in the sort of jurisprudence it publishes, but also in format. So the book contains a number of book reviews, for example, but it also has a few interviews and full-length scholarly comments, articles, and some student commentary as well. It's a very diverse project, and the collection in the new edited book reflects that. There's no question that the German Law Journal was one of the first fora for legal scholarship to stake its place in the virtual world. It really is among the first generation of those efforts. And at the time, there were real pragmatic reasons for pursuing that, and some visionary reasons as well. But among them is simply the speed and flexibility that virtual publishing makes possible. And we had always hoped that the German Law Journal would be flexible and responsive and current, always current. And publishing electronically makes that a reality in ways that print media can never achieve. That's meant over time that we could publish special issues responsive to particular jurisprudential events. For example, the German Law Journal was the first legal publication in the world to respond to the events of September 11th with a series of articles, a special issue in which people in the moment of that trauma still were reflecting in rather, maybe not a scholarly fashion, but an emotive fashion on the effect of those events on international law. Another really successful example was the publication of a special issue in the summer of 2009, just days after the German Federal Constitutional Court issued a groundbreaking decision on Germany's ratification of the European Union's Lisbon Reform Treaty. The German Law Journal was first to do that. It did so with really heavyweight scholarship, and that continues to be one of the most widely cited treatments of that development even years later.